Okay, that was obviously Minister Tony Butty, who is our minister and who is guiding the passage and implementation of the Act as it comes into effect on the 1st of July. So as indicated on this slide, that is the key date that we are moving towards for the new Act to come into effect. On that date, not only will the Act come into effect, but so my apologies, I've just had feedback that there was no volume on the minister's message. I think we'll move on, and if there's an opportunity to have that at the end. Essentially, the minister was welcoming people to participate to the workshops and thanking people for their involvement in the process and acknowledging the role of Aboriginal people as part of the new legislation. Anyway, the new Act will come into effect from the 1st of July. The regulations will also be coming into effect from that date, and I'll be discussing regulations in more detail later on. And we also have the repeal of the Marandoo Act, which is a very important occurrence, the repeal of that particular act, but it does only affect a very small number of players and doesn't affect people more broadly. The relevant parties involved in that process have been closely engaged in it over quite a while now, and that's a highly significant step in terms of the overall operation of this new Act. For those who are familiar with the current Aboriginal Heritage Act, those processes will continue for a limited transition period of 6 months. That will allow for existing applications, whether they're applications for Section 18 notices or for Regulation 10 applications in relation to more minor approvals that are required. They will be able to continue and be dealt with for a further 6 months. And the role of the Aboriginal Cultural Material Committee that is established under the existing Aboriginal Heritage Act will continue to allow for that process to occur. At the end of that 6-month period, the Aboriginal Heritage Act will cease to exist fully. The Aboriginal Cultural Material Committee will also cease to exist, and we will have transitioned entirely into the new legislation. So this year has been, or has been and continues to be an extraordinarily busy year, and obviously is the culmination of many years of work by a large number of people. In addition to that proclamation of the Act and the gazettal of regulations and other statutory guidelines, there have been a number of steps that have been involved in terms of trying to ensure that we are well placed for the new Act and new systems to come into effect. I'll be talking more about the local Aboriginal Cultural Heritage Services as we move on. But in recognition of the key role and function that these organisations or the Aboriginal organisations that will take on these roles will play moving forward, the government has provided a range of funding opportunities for those organisations. The initial funding opportunity is what are called readiness grants, which enables Aboriginal organisations to identify the capacity that they have to take on that particular role of being a LARCS. In addition to the grant funds for as part of that process, upon designation of a LARCS by the Aboriginal Cultural Heritage Council, each LARCS will receive a $200,000 grant on appointment, and the Minister has also announced ongoing operational funding for LARCS in recognition of the very important role that they will be undertaking as part of the new legislative regime. I mentioned just in the Aboriginal Cultural Heritage Council, it was appointed and established in September last year. There were 7 members of a total potential of 11 that were appointed last year. The government is going through the process of finalising the selection of the remaining 4 members. So that is underway, and there'll be an announcement prior to the 1st of July in relation to those remaining 4 positions being appointed by the Minister. We are putting in place a whole new ICT system called Acknowledge, and that is obviously a key aspect of the whole new regime. It's intended to be a one-stop location for people to be able to engage with the new system, engage with the department, and have the information that they need readily to hand. As I mentioned, we're doing a series of workshops as part of our education program. We've had quite a few so far. As I mentioned, we have undertaken some public workshops already. There were a couple last week, and we're undertaking further workshops throughout the state. And as I mentioned, they've been very popular in terms of their uptake. We've got that repeal of the Marindoo Act. We have 78 protected areas, and I'll be touching in more detail on what a protected area is about later on in the presentation, but we have 78 of those. These are areas that are of the highest or most outstanding significance to Aboriginal people that need to be transitioned across from the old system to the new, and that will all be occurring. We are developing, in conjunction with the Department of Training and Workforce Development and TAFE, a training program in relation to the new Act. We're working very closely with both of those organisations in terms of developing education modules initially, and then will be the intent is to move to a certificate course that people will be able to register for and get a formal qualification through. And obviously, with a change of this magnitude, there's also a considerable amount of work that is required within the department that we are currently working on, including moving existing staff across from old to new, and also identification of new staff that will be integral in the undertaking of the new Act. So many of you will probably have been on the journey with us as we went through the process of developing the bill that ultimately resulted in the new Act. It was an election commitment of the then opposition prior to the 2017 election. With the election of the McGowan government, Minister Ben Wyatt initiated the review process for the current Aboriginal Heritage Act. So that kicked off in 2018. There were 3 years of engagement and consultation for that. With the release of a bill in September 2020 for consultation on the bill. There were many changes made in response to the feedback that was received on the bill prior to it being introduced into Parliament late in 2021, and was passed in Parliament in December and was given royal assent later that month. The new Act is very different from the current Act in a range of respects, and I'll be going through many of those differences as I move through the presentation and get into more of the detail. A number of the key ones are those that are on this slide. So, for example, under the new Act, there isn't an assessment of what is important and significant to Aboriginal people in terms of their heritage by a government committee. I've already mentioned the ACMC, the Aboriginal Cultural Material Committee, which undergoes a statutory responsibility in terms of assessing whether Aboriginal cultural heritage in fact meets certain criteria that are set out in the current Act, under the current AHA. A lot of Aboriginal people, as would be expected, object to the fact that a central committee has been established to make decisions about what heritage of theirs is important, significant, and so under the new Act, it's up to Aboriginal people themselves to make that call as to what is important and significant, and therefore what warrants and deserves the protection of the Act and the processes that are outlined in the Act. The new Act sets out a clear due diligence process that proponents are required to undertake. Under the current system, proponents are not required under the Act to engage with Aboriginal people. The process is very much about submitting a notice into the system, into the ACMC, and it works its way through there. And there's no statutory requirement for proponents to have any kind of engagement or consultation. So the new Act very clearly puts that in place in recognition of the important role and the fact that the people whose heritage that is being impacted need to be able to have a role and a say in what those impacts look like. So clearly that engagement is front and centre as part of the new regime, and there's formal recognition of the role of native title holders, knowledge holders, as well as traditional custodians. There's that ability for Aboriginal organisations to be appointed as ALARCs in recognition of the key role that those organisations will undertake. There have been some substantial increases in penalties where there's an offence. The penalties under the current AHA have not shifted, I think possibly since the Act was first passed. And we also have now got a new suite of protection mechanisms that the Minister for Aboriginal Affairs can exercise, including stop activity orders and prohibition orders. These have been modelled on the Heritage Act and the powers available to the Minister for Heritage. So the Minister for Heritage and the Heritage Act deal with non-Aboriginal cultural heritage, more commonly known as historic heritage, and those powers exist under the Heritage Act, and the new powers under the Aboriginal Cultural Heritage Act are modelled on those particular powers. This slide identifies that heritage protection is very much front and centre of the new Act, that there are a range of mechanisms that support that heritage protection focus of the new Act. The two items, the top right hand of the slide with the asterisks, they're the only two that currently exist in the existing regime under the AHA, the Aboriginal Heritage Act. All the other items listed there are new to the new Act and provide that greater level of protection, involvement of Aboriginal people, and ensuring that the processes are clear and certain for all parties involved. I won't go into any detail in relation to each of these items because they'll all be covered as I move through the presentation in more detail. So again, the new Act is very clear about what it's seeking to object, and this is set out in the objects as well as principles in the Act. So the objects highlighted and the principles highlighted are those that are reinforcing that the role of this Act very much is to have that recognition, protection and conservation of Aboriginal cultural heritage, and that where there are activities that may harm that heritage, that those processes need to be clear and provide certainty to all parties involved, but that there need to be balanced and beneficial outcomes for Aboriginal people as well as the wider WA community. The principles clearly identify that Aboriginal people should, as far as practical, be involved in that recognition, conservation and preservation processes, as well as where there may be activities that harm Aboriginal cultural heritage. And under section 10 on the bottom right hand of the screen, the principle is that the values held by Aboriginal people in relation to Aboriginal cultural heritage should be prioritised when managing activities that may harm Aboriginal cultural heritage, and certainly the processes set out in the Act ensure that that prioritisation does exist in practice. So I will briefly move through the first parts of the Act, the first parts that deal with much of the setup and some of the more important protection mechanisms before I move into part 6. Part 6 of the Act deals with the approvals process and is obviously of primary interest to many people. So I'll be going through that part in more detail, but I will hopefully, if our IT has been sorted, I'll be pausing at the end of this section just so people can have a chance to reflect on things that I've said, and with a bit of luck we'll be able to provide comments or questions. So the first part of the Act is where it set out that Aboriginal people should determine what Aboriginal cultural heritage is protected. As I mentioned, under the current system, any sites or objects, Aboriginal sites or objects that are submitted need to meet criteria set out in section 5 of the current Act, and the role of the ACMC is to determine whether or not they meet that threshold test. As I mentioned in our many workshops in the development of the bill, this was a really strong point that many Aboriginal people raised, that it shouldn't be for others to make that assessment as to importance or significance. And it's also worth noting that the ACMC itself, which has a majority of Aboriginal people, also finds that problematic because it's about people making a decision about other people's country, and obviously that's not in accordance with Aboriginal tradition in any sense. We have a large number of existing registered sites and lodged places. The difference between the two, for those that are not familiar, is that registered sites that are those that have been through the ACMC process, and the ACMC has made a formal decision on them. Lodged places are those where we have received information, but they haven't yet been through the formal process. Under the new system, there won't be that distinction. One of the challenges that we have with the current system that's been highlighted in the workshops that we've been undertaking is that there's this misunderstanding that it's only Aboriginal sites that are on the register that have a level of protection. So if it's not on the register, then there's no Aboriginal heritage there, and there's no need to take any precautions in that respect. As I mentioned earlier, there is blanket protection under the current Act, as there will be under the new Act, and places don't have to be on the register, but the fact that we have a register at all just creates that misunderstanding. So under the new system, we're just going to have a directory. So any information that we have about Aboriginal cultural heritage, whether it's sites or lodged places, and new information that we get will go onto the directory, which in effect will be a data source for anyone who's seeking to do an initial check as to what information there may currently be in the system. Part 2 of the Act is the one that sets up both the council and the LARCs. As I mentioned, the council can have up to 11 members. It's required to have 2 Aboriginal co-chairs, male and female, in accordance with Aboriginal tradition and custom. And it also has an additional 9 members, but must be majority Aboriginal membership. We have 7 members in total at the moment, and as I mentioned earlier, the government is going through an appointment process for the remaining 4 members, and announcements about that will happen reasonably soon. The role of the council is a significant one. It designates the LARCs, so those Aboriginal organisations that want to take on that formal role of being a LARCs, the council's role is to designate them. The council also approves permits in relation to Tier 2 activities, and where parties can agree a management plan that is required for a Tier 3 activity, then the role of the council is to assess whether or not the process has been gone through, but then to approve the plan. Where the parties can't agree, then the role of the council is to make a recommendation to the minister in relation to management plans. And if you're not particularly familiar with the language around tiers or activity tiers and the plans and permits processes, then I'll be getting into those in more detail shortly. The LARCs, the Local Aboriginal Cultural Heritage Services, are a recognition that is Aboriginal people at a local level who need to be involved in those processes. So it does give that active role for Aboriginal people in heritage management. It will form a one-stop shop for proponents who are seeking to engage with Aboriginal organisations. So where there is a LARCs, proponent will only need to engage with that LARCs. They will have a clear role in negotiating management plans as well as providing advice more fully. In recognition of the key role that they will be taking, as I mentioned earlier, the government has established funding for capacity building. So there are a range of grants that are available, as well as the operational funding. In recognition of that key role, LARCs will also be able to charge a fee for service for their engagement in the process, which they'll be able to charge to proponents. And I'll be again touching on that in more detail later on in the presentation. Another aspect that came across really clearly through the process in the developing of the bill was the need to have recognition and protection of key aspects of Aboriginal culture. So ancestral remains in particular were highlighted as a key issue, as well as secret and sacred objects. Ancestral remains under the Act must be returned to their rightful traditional custodians. This is a mandatory requirement that applies to anyone who may happen to have ancestral remains. While we don't expect there to be many people outside traditional custodians who do have these, we are aware that instances do pop up where people have, for whatever reason, historically had these remains with them, and the Act will now require that they are returned to those traditional custodians. Secret and sacred objects, government agencies will be required to return those to their traditional custodians. This requirement hasn't been extended to non-government people, private people who may have these in possession. This is in recognition of the fact that people may well have purchased or obtained them legally and private property rights apply, as well as the fact that there are certainly cases where secret and sacred objects have in fact been handed to someone else to look after or for some other reason, and that also needs to be respected and recognised. The Act does, however, limit the fact that they can't be taken out of Western Australia and that they can't be sold. So there's still that recognition that these are really important in Aboriginal culture. and that they need to be treated as such. And so those limitations do apply to make sure that they do stay within the state and they can't in fact be sold. I mentioned earlier that we have 78 protected areas. So these are areas of outstanding significance to Aboriginal people. There have been 78 that have gone through the process since the 1972 Act came into effect. With the advent of the Native Title Act, however, 1993 Native Title Act, we haven't been able to determine any more protected areas because of the inconsistencies with the Native Title Act, particularly around native title rights and interests and the potential for the future Act provisions under the Native Title Act applying. So we're changing that under the new Act. They will still have that highest level of protection that legislation can offer. But the key difference is that the current system has exclusive vesting in the Minister for Aboriginal Affairs. So this is a quirk of the current system and current regime, is that when the drafters of the current Aboriginal Heritage Act were preparing the bill, presumably back in the early 70s, no doubt with absolutely the right intent, but the decision was made that for these areas of the highest level of significance to Aboriginal people, they should have exclusive vesting in the minister, and so only the minister can enter those areas, and Aboriginal groups then can't have an active management role, even though it is actually their heritage that has that highest level of significance involved. So we're removing that vesting in the minister. We still, as I said, will have that retention of that high level of protection, but it does in fact mean that those Aboriginal groups and those Aboriginal people whom that heritage has that highest level of importance and significance can in fact manage, play a role in managing those areas if that's what they wish to do. So I've just got a couple of slides just to go into slightly more detail about protected areas, because it is of such importance to Aboriginal people, but also because of the implications of protected areas. So there is a difference in terms of the fact that protected areas can only be nominated by a knowledge holder or Aboriginal community or group with knowledge holders for the area, that they actually consider it, or that person considers it to have that outstanding significance. And there's some guidelines that I'll be touching later on that go through the kinds of criteria or the kinds of values and factors that need to be addressed in the nomination for protected areas. It does go through a process and ends up being approved by the government in recognition of that importance of the area in question. It doesn't require that the knowledge holder or the community that includes knowledge holders provide evidence as to why, or provide any culturally sensitive information about areas, but it is about ensuring that there's sufficient evidence as to why it does have that level of outstanding significance. And for everyone else, the really significant element of protected areas is that they, in essence, sterilise the area for any harmful activities moving forward. So as it indicates towards the bottom of the slide, where a range of activities can potentially occur in relation to other forms of Aboriginal cultural heritage for protected areas, no harmful activities can be undertaken. That includes exempt activities. Conditions and regulations can be put in place, but they will be very much tailored to the protected area in question and the intent behind it, and invariably will be involving the input of the Aboriginal people from whom it has that outstanding significance, just to make sure they can in fact undertake the activities that they consider appropriate in relation to those areas. And this is the process for protected areas. So I won't touch on this in too much detail, but essentially, as I've mentioned, a knowledge holder will need to provide an application, put in an application. The ACHC, the ACH Council will then undertake a process. It will initially consult with other Aboriginal people in the area to get their views. And then if it forms a preliminary view that there is the potential for this to be a protected area, we'll then go through a consultation process more widely, particularly with people who may hold an interest in that land. So if there are people who hold any form of interest, any form of tenure in that land, then they will have the opportunity to have a say in the process as to whether or not it should be become a protected area. It's worth noting that of the current 78 that we have, the vast majority are actually really quite small areas. They are very localised. They really are highly significant places where particular ceremonies or particular activities may be carried out that have particular significance to a person or to community. They don't tend to be particularly big or widespread because they do have that very important focus for people. And as I mentioned, that there will be the ability for conditions and regulations to be put in place just to make sure that Aboriginal people can in fact manage those areas if that's what they wish to do. Other examples are where there's significant rock art or petroglyphs, and one of our most well-known protected areas, Woodstock Abydos, is estimated to have over a million bits of rock art on it, just to highlight the kinds of significance that we are recognising through these processes. Where the council makes a recommendation to the minister makes a decision in the form of a recommendation to the governor. The minister does need to go to the governor, or the governor does make the decision for a couple of reasons. As I mentioned, it is that formal recognition that these are areas of the highest level of significance to Aboriginal people and are being recognised as such. And it also ensures that they go through the full government process. So there is the opportunity for the minister to engage with his ministerial colleagues in making this decision. As I mentioned, because it does have that sterilising effect, it's important that that whole position is in fact taken in relation to those. Where protected areas do exist, and that is the case for the current 78 as well as any ones declared in the future, they then can only be removed with the approval of both houses of parliament. So that's the highest level of protection that can be given within legislation. So it's similar to Class A reserves in the environment area, that they have been recognised through Parliament being the only body that can then remove them. So I'm going to pause it there, and I'm going to be hoping that my staff with me are reassuring that people can provide questions and comments. I'll pause for about 5 or 10 minutes. Okay, so it appears that we do have an issue. I'm just going to seek advice. If you can just hold on.
It's not like the Q&A, but if they go into their chats bit, the meeting should be there.
We've got that here. So in the meeting chat, can people can you write a question in the meeting chat? So if you click on the chat function, we think that there's the potential for, a message is coming up at the moment. Yes, so my apologies, maybe it's a form of terminology, but it's in the meeting chat that we're just wanting to see if people can in fact put comments or queries. So I've got Boyana has asking, is anyone else able to have a go and just to see, and if someone internally within the building who's not actually with me could just send me a message as well, just to let me know if this process is working. We did test this and it was working fine before, but as is always the case, when you actually go live on these things, some glitch seems to arise and it stops working. So at this point, I'm not getting any indication that there are any questions, or at least people being able to engage with the process. While we are doing this pause, I'm just going to have a think, because I'm very conscious that I'm talking a lot and people do need a break from my voice. I also need to just make sure my voice doesn't give out. Okay. My apologies all, despite our best endeavours and checking beforehand, it appears that we're having some issues that it's working internally, but doesn't appear to be working externally. So my sincere apologies about that. So I will be providing an email address at the end of the presentation, and if you have got any queries or comments, then you can certainly forward them through, and given we're not going to be able to answer them through this process. And again, my sincere apologies about that. It was intended to be an interactive session. Then we'll do our very best to respond to those queries as quickly as possible. So perhaps jot down any queries as I'm going through the process, and we will respond to them as quickly as possible afterwards. Oh, okay. All right, so we're going to try a shortcut in that we will in fact have the email address open. So the email address is achimplementation@dplh.wa.gov.au. So ACH implementation, or one word, at DPLH for Department of Planning, Lands and Heritage .wa.gov, which is gov.au. Okay, now seems to be getting that it, in fact, oh good, thank you all that are saying that it is working. Okay, so if there are any questions, let's use the chat function. And the initial question that I've got is, what about areas where a protected area has been proclaimed, but there are legacy users in that area who generate a significant food resource and revenue for the state? So for existing protected areas, we are very much talking to legacy users. Not sure, and I had this question at a workshop I did on Saturday about that. There may be protected areas that are within, so certainly it was has been brought to our attention that there are protected areas that might be within, say, paddocks and the like, but it's not the actual protected area itself that is being used for that purpose, often because, as I mentioned, they often have a particular functional role, ceremonial site or as such, and generally something there that would the advice that we certainly get is that would limit any other use of those locations, whether it's because there are significant rock formations or the like being used. But we are in touch with anyone who has an overlap or for where there is a protected area. We've been in contact with all people. So if you do have one in question that you have a concern about and we haven't reached out to you, please contact us on that ACH implementation at DPLH web email address, and we'll be sure to follow up. But as I mentioned earlier, protected areas do currently have that limitation in that only the minister can have access, or the minister can grant approval. And if that currently doesn't exist, then there shouldn't be any activities that are currently occurring within those areas. But would reiterate that there are in fact only 78 of them. They are scattered throughout the state, and they do tend to be fairly small locations. But if you do have any concerns, please feel free to contact us. So I'm going to move on now to, okay, thank you, Caroline. As I mentioned, if you'd like to email us directly with more details, and I'll get an officer to contact you afterwards. So this slide shows the central role of the LARCs, the Local Aboriginal Cultural Heritage Services. It's important to note they need to be existing corporations. So the new Act isn't trying to establish a new form of organisation. It's not trying to put in place any new process for establishing organisations. It's recognising that there are in fact existing Aboriginal organisations, Aboriginal corporations that are out there that may well be in a position to take on this role. So the ones listed are native title parties, in particular prescribed bodies corporate. So if you have any familiarity with the native title process, obviously where there's been a determination of native title, a PBC is established. They hold the native title rights and interests on behalf of the Aboriginal community for that area. And so they are very well placed and actually have primacy through the new Act in terms of taking on this role. This extends also to regional corporations that may have been established under alternative settlement agreements, such as in the southwest and Yamaji region up near and in and around Geraldton. So a key role of the LARCs will be to have that engagement with local knowledge holders. As I mentioned, proponents will then only need to go to a LARCs. Where there isn't a LARCs, and this will be touched in more detail later on, but where there isn't a LARCs, there'll be a need to engage with both prescribed body corporates or native title parties where one exists, and the knowledge holders. However, where there is a LARCs, it'll be up to the LARCs to manage that process. And in many instances, they will obviously be extremely well placed to do so. So it is a formal recognition that they are often people who the PBC or the regional corporation are in fact best placed to have those conversations, that there is often a very strong overlap, but the Act is recognising that that's not always the case, and that there are potentially differences between who holds native title and who in fact may hold knowledge for a particular site. This is particularly given the legacy of colonisation within this state and the fact that Aboriginal people were forced off country and away from traditional locations. The LARCs will obviously have that key role in relation to the council, providing input to the council and its processes. And as I mentioned, the proponents will only have to have that engagement with the LARCs. So Part 6 is the most significant part of the Act. It's certainly the longest part of the Act, and is one that's obviously had the most interest to the vast majority of people, given what it deals with. It replaces the current Section 18 process under the AHA, the Aboriginal Heritage Act. So if you're not familiar with that Section 18 process, those points listed are the things that have been highlighted as considerable flaws, significant flaws with the existing process, and that needed to be addressed in developing the new Act. So there is no requirement to consult or have any engagement with Aboriginal people. There isn't that alignment with native titles. Obviously, the AHA predates the Native Title Act by 20 years, and it hasn't been updated to reflect the fact that native title now exists, and that there are significant processes that have gone through in terms of people identifying connection to country and having determinations of native title. The current Act doesn't allow for where new information may arise. This was highlighted most noticeably with the Dugan Gorge rock shelters incident back in 2020. That example, that situation highlights a number of flaws with the current situation, and so I do draw on that example, not picking on that proponent in particular, who certainly came out and acknowledged flaws with the process that led to the destruction of those rock shelters, or the near destruction of those rock shelters, but it does highlight some of the flaws with the system. So the new Act does allow for that new information to be dealt with if and when it arises. The current system essentially has a one-size-fits-all, so no matter what kind of project or activity you're undertaking, unless it's a really minimal one to which a Regulation 10 approval might be only required. If it's of any kind of significance, a Section 18 notice is required. And this includes whether or not the parties have agreed to the Section 18 notice. So I think it's fair to say the majority, in fact, probably the vast majority of Section 18 notices that are currently submitted into the system and are considered by the ACMC, the proponent has, while they're not required to do so under their legislation, in most cases, the proponent has sat down and had those conversations. To some degree, that the impetus for that has occurred both with the under the current government. Minister Wyatt, in particular, initiated processes where he was keen to make sure that proponents were having those conversations, and the ACMC likewise has been expecting proponents to have those conversations, despite the fact that the Act doesn't require it. And in many cases, proponents are doing exactly that and are sitting down and having conversations and negotiating outcomes. So that in many instances results in a Section 18 notice that isn't having an objection by the Aboriginal parties. But even if that's the case, it still ends up on the desk of the minister who has to give the final consent. And this was one of the issues that was highlighted through the consultation on the bill, was that there was a belief, sometimes very much in good faith, but still not consistent with the legislation, that if there had been those conversations and the relevant Aboriginal people had consented, then in fact the activity was good to go ahead with. That's not the case. That consent is sufficient. The Section 18 process, the minister's consent is also required. So the new process is very much trying to get away from that. And if the parties can in fact agree, then that's essentially where it should end, with an approval role of the council. Approvals aren't time limited under the current system for Section 18 consent, so they are invariably for the life of the purpose for which the notice has been submitted and for which consent is sought, but that defined time frame, and this often it can be quite uncertain as to exactly when that purpose has finished. And if we're talking with large mining activity, for example, that can stretch into 2 decades. Approvals also be cancelled or suspended if there are issues that haven't been resolved or addressed properly, then the Act is limited in what it can do there, and I make mention of the Minister's new powers, and also decision making isn't transparent. So under the Act, only a proponent needs to be advised by the Minister as to the outcome of their notice. Aboriginal parties aren't actually advised. So while that process has been changed in more recent years, and the Minister does write to both, prior to that was a degree of, to some degree, salt being rubbed into the wound, where it was the proponent who has obtained the consent from the Minister, potentially over the wishes of the local Aboriginal people, and it was the proponent who was advising the Aboriginal people of the outcome. So there's provisions in the new Act for both notification of decisions as well as reasons need to be provided. So these were the policy objectives that were sought to be achieved and that were reached during the consultation process on the bill itself in those 3 years leading up to the development of the draft bill, that Aboriginal people and proponents should work together to reach agreements regarding the management of Aboriginal cultural heritage. As I mentioned, in many instances that does happen now, not in every instance, and that does depend to some degree on the parties involved and the approach that's being taken. But it does occur, and that needs to be the focus, the primary focus of the new Act, that agreement making, and the Act is very much set up to achieve that outcome. That there should be an underlying philosophy that land use activities, ground disturbing activities should be managed in a way that avoids and minimise harm to Aboriginal cultural heritage where possible, and that's a theme that runs throughout the Act, and I'll be touching on that in more detail in relation to the specific tiers. The system needs to provide clarity and certainty of process and consultation for all stakeholders, so people understand what's involved and what's required and the timeframes that need to be met, and after which they can have confidence that the system will move on and an outcome achieved. That the system needs to ensure that well-informed decisions are made. This is particularly in terms of the engagement between proponents and Aboriginal parties, that the proponent needs to provide all information that's relevant to ensure that Aboriginal parties involved are understanding what's being put to them and what's at stake, and therefore having a proper discussion about matters in an informed way. As I mentioned, the current Section 18 process is very much one size fits all. The Minister's consent is required irrespective of any level of agreement or irrespective of the size of the activity or project. So the new Act has different levels and different processes that need to be applied, which does very much focus on the level of impact an activity may cause. And obviously, Aboriginal people do need to have that involvement, so there's statutory requirements for engagement set out throughout the Act. But also importantly, approval is in fact required when the proposed activity may actually harm Aboriginal cultural heritage. So it's not the case that if you're undertaking an activity that does fall within the activity tiers, and essentially every activity that is undertaken in Western Australia needs to be captured in those activity tiers and I'll touch on that later on. but they only need to go through an approval process where they in fact may harm Aboriginal cultural heritage. Where there's no risk of harm, then the Act doesn't apply and the approval processes just don't apply. So we have 4 different categories of activities that are set up by the Act and regulations. There are a range of exempt activities that do not require any form of approval. These are included in both the Act and the regulations, and they include things like small-scale residential development, obviously emergency services and emergency activities. If there's an emergency, then people need to be able to respond to that. Recreational activities undertaken on public land are exempt, and importantly, like-for-like activities. So where an activity is being undertaken that is consistent with activities that have been undertaken previously, then they are exempt. Tier 1 activities are no to minimal ground disturbance, and they don't require an approval. Proponent is required to take all reasonable steps possible to avoid or minimise a risk of harm. So again, this is that underlying philosophy. I mentioned that the Act is encouraging or focusing on people taking those reasonable steps to ensure that even if they are only undertaking a tier 1 activity, that that avoidance or minimisation of harm does occur. So for example, if you're undertaking a tier 1 activity and there's an artefact scatter that you recognise, or there's rock art, then doing the right thing and, where at all practicable, avoiding that heritage to avoid that harm occurring. For low ground disturbing activities, these require a permit. These are tier 2 activities and will require a permit issued by the council. There's a notification process that I will touch on shortly for the Aboriginal parties to have a view. The council then issues the permit, and the council needs to be satisfied that all reasonable steps possible are being taken to avoid and minimise that harm. And for tier 3 activities, so these are moderate to high ground disturbing activities, where the parties can agree, then the management plan is submitted to the council, who then approves the plan subject to checking on various aspects. And we do expect, and certainly the process set up under the Act is that we expect the vast majority of management plans will in fact be agreed, and as I mentioned earlier, the large number, or the majority of Section 18 notices are in fact the parties have reached a level of agreement where the Aboriginal people do not in fact object to what's proposed. It's not always the case, and there's certainly very robust discussions, but certainly proponents are undertaking steps to avoid causing harm where that is at all practicable, and so we anticipate that will continue under the management plan process under the new Act. Where parties can't agree, however, where there isn't agreement reached in relation to management plan, then the role of the council will be to assist the parties where it can to reach agreement, and otherwise to make a recommendation to the minister as to whether or not the minister should authorise the management plan, and the minister's decision is final in that respect. So this sets out a brief illustration of the comparison of the processes under the current Act and the new Act, the Section 18 process under the AHA and the tiered process under the new Act. So as it shows there, a proponent submits a Section 18 notice for consideration by the ACMC. There isn't any due diligence required or consultation required by the proponent. The ACMC will undertake its own procedural fairness process, so it will go out to Aboriginal parties to seek their views on these matters, just to ensure that those views are taken into consideration. But there isn't any consultation required by the proponent, and there isn't any formal consultation required in the AHA for the ACMC to do so. That recommendation is then made to the minister, and the minister needs to make their decision based on the advice recommendation of the ACMC as well as the general interest of the community, but that's not further defined. And then the consent can be granted and impact occurred. Under the new system, we have the 4 different pathways. So exempt obviously can proceed, although there is still that encouragement to take those steps to avoid and minimise harm. For tier 1 activities, there isn't a formal authorisation required, other than there is that statutory requirement to in fact take those steps. Tier 2 activities for low ground disturbing activities. There's a due diligence process, or the due diligence process applies to all 3 tiers of activities, and the due diligence process includes checking the tier of activity, and subsequent to that, it's then a notification process for the Aboriginal party. So the proponent will need to notify the Aboriginal parties of the intent to submit the permit and allow a period of time for submissions. It will then be, the permit will then be submitted to the council. The council will then go through a similar process of in essence, ensuring procedural fairness exists and that Aboriginal parties have the opportunity to have a say in relation to the proposal for the issuing of a permit. And then the council will make a decision and advise the parties of the outcome. For the Tier 3 activities, for the moderate to high ground disturbing activities, again, there's a due diligence process that's set out under the Management Code, which I'll be getting to a little later, which sets out which helps identify which tier that the activity falls within. Then there's a statutory requirement for that consultation to occur. So appropriate consultation, which is set out in the consultation guidelines. If it's confirmed that in fact there is a risk of harm to Aboriginal cultural heritage, then there'll be a need for a management plan. And the Act requires that such a plan is negotiated with the relevant Aboriginal parties. Where that agreement can be reached, then the council gets submitted to the management plan gets submitted to the council for the council's consideration and approval. And where the parties can't agree, then the council can undertake a role, including mediation, and then make a recommendation to the minister as to for the minister to make a decision. The minister's decision is made public, and reasons are given for the basis of that decision. Management plans will need to set out a number or address a number of factors and issues. Obviously, first and foremost, it will need to identify how an activity is being managed to avoid or minimise impact to Aboriginal cultural heritage. As I mentioned, however, where the parties can agree to a management plan, that's entirely up to the parties, obviously particularly the Aboriginal party, to agree to what harm, if any, should occur to Aboriginal cultural heritage within the area of the management plan. The underlying philosophy of the Act, as I've mentioned, is very much that it is the heritage of the Aboriginal people whose heritage it is who need to be involved in that decision-making process. They need to be involved in those consultations and discussions around what should go into the management plan and what activities or how those activities should be managed to avoid or minimise that harm. But if they do in fact choose to allow harm to occur, and certainly that does occur currently, albeit reluctantly, there are instances where Aboriginal people do agree that certain activities can occur which may harm their heritage. If that occurs, then that's between them and the proponent in question, and that is reflected in the management plan. It's not then up to the council or government to second guess that decision. So the role of the council, where the parties have agreed, is not to have an independent look at the management plan and decide whether or not they agree with the activities involved and if there is any harm, whether that harm should occur. That entirely is the role of the local Aboriginal people whose heritage it is. The role of the council will be to make sure that there is that informed consent. So the management plan will need to set out that impact statement. Will need to include an impact statement that identifies what heritage is being impacted and include the details of that impact. And where the parties have in fact agreed, it will need the proponent and the management plan will need to set out that informed consent has been provided. As I mentioned earlier, the Act does very much focus on agreement making, but it's also very clear that where conversations are being had and where management plans are being negotiated, that the Aboriginal parties do need to give informed consent, and the Act sets out a definition for that. So unlike the current Act, which just refers to the general interests of the community, the new Act does set out things such as definitions for informed consent, and as I'll refer to later on, the interests of the state. And in the case of informed consent, that involves the Aboriginal parties having full and proper disclosure of information from the proponent. So the proponent will need to make sure they do give all that information as to what they're proposing to undertake. This includes the method by which they're intending to carry out the activity, as well as any feasible alternative methods. So again, the focus very much on is that if there are different ways of undertaking an activity which may have different levels of impact or cause different levels of harm to Aboriginal cultural heritage, then that information does need to be provided to the Aboriginal parties so they can make a fully informed decision. And the consent must be given voluntarily. There can't be any coercion or manipulation of any kind. And as is referred to in the next dot point, there can't be any non-objection clauses or gag clauses as they're better known. We are aware that there are existing agreements where Aboriginal people have signed up to agreement where they have agreed that if the proponent issues a Section 18 notice that they will not object to that. That's a statutory right that exists, and so the Act is very clear that people can't give away or be forced to give away any benefits that the Act exists or bestows on people. That applies to both Aboriginal people and proponents, but in particular it does mean that those gag clauses that are found in some native title agreements are of no effect, and does ensure that that consent is being given voluntarily without any other form of intimidation or potentially manipulation. Management plans will need to have contingency arrangements in place for any new information. So despite the fact that the process is very much set up to ensure that all relevant information about Aboriginal cultural heritage is identified before the negotiation process is undertaken, there is always the potential for new information to arise, particularly given the vastness of the state and areas where activities are being undertaken. There's always the potential that things will be discovered despite the best intentions for parties to that knowledge is obtained prior to entering and negotiating a management plan. New information can take the form of new places or new objects, for example, but it could also be that it's about new information about something that's already known. And again, the Juukan Gorge rock shelters is the best example. So when the Section 18 consent was issued back in December 2013 by the Minister, the condition was that the proponent, Helmsley Iron, back then, did undertake further archaeological excavation, which they certainly did. They met those requirements, and it was as a consequence of those archaeological excavations that the true age of the rock shelters was identified. So the age was understanding of the age of the rock shelters was increased by about 20,000 years to 46,000 years old, which is one of the oldest known human habitation locations in this state, and obviously took on an added level of importance and significance as a consequence. But the process didn't allow for that new information to be dealt with. So there wasn't anything that said, if once you do get this information that you're doing via the excavation, then what? So while the proponent did in fact do the right thing, there wasn't any ability to then respond to that new information. As I mentioned, where the agreement is reached, then it's up to the council to approve the plan, and where the agreement can't be reached, and the council needs to consider the views of the Aboriginal party in terms of making a recommendation to the minister, as well as that of the proponent. The Act sets out a formal role for the council in this regard, so the council can offer to the parties to help them reach agreement if that would be of benefit. And that includes undertaking a mediation function. So the council can act as a mediator, or it can appoint someone on its behalf to act as a mediator to really try and see if agreement can be reached, because obviously that's the primary aim of the process, that the parties do agree an outcome whereby everyone is satisfied with that, and it's not being left to ultimately the minister to make that final decision. I think it's fair to say that no minister particularly wants to be the one to make the decision where the parties can't agree, and so the key role of the council is to try to assist the parties to achieve those outcomes where that's at all possible. So, as mentioned, the role of the minister is only where the parties can't agree. If the parties can agree, then unlike the current system, it doesn't need to end up anywhere near the minister. Both the council and the minister can only make a decision if they're satisfied that consultation has been undertaken. So it's consultation in accordance with the Act and is set out in the consultation guidelines that I'll be discussing a bit later on. and that there are in fact reasonable steps in place to avoid and minimise the risk of harm. So obviously where the parties can't agree, so where the Aboriginal parties haven't been able to agree or haven't agreed to what the proponent is seeking to undertake, then that positive obligation on the proponent to take all reasonable steps to avoid and minimise harm does then exist to make sure that that is in fact the case. And the minister must also take into account, it needs to be satisfied that what's proposed is in the interest of the state. So unlike the current Act, and I've mentioned the minister under the current system needs to have regard to the general interests of the community. Under the new system, the minister must have regard to the interests of the state, but this time it is in fact defined. And the definition includes that it needs to take into consideration the economic and social interests of Aboriginal people as well as future generations. So this is very much, again, acknowledging, as the Act does the whole way through, that Aboriginal cultural heritage has existed in many instances for thousands, if not tens of thousands of years, and that it has that potential to continue to do so into the future, and that any decision at a particular point in time in relation to a particular activity needs to give that appropriate consideration to those factors when that decision is being reached. And then the minister is required to give a notice of their decision as well as reasons for their decision, so the parties understand the basis for that decision. So I'm going to pause it there just so people have a brief respite from the sound of my voice and I can get a quick drink. And also, I know that questions have been coming through, but I will give a pause for about 5 to 10 minutes just so that people can go back or consider the information that I've provided and submit any queries that we will do our very best to answer. I'm not sure how many people we have online at the moment, but but we do have quite a few questions that have come through already. if I get back to that.
There you go.
Okay. Just making sure that, yes, hopefully people can hear me again. So we've had a few questions. Just saying that I thought I had unmuted. Okay. Hopefully have managed to unmute the mic for a second time. So we have had a number of queries come through primarily by email. I'll attempt to answer some of them, but some of them are getting into quite specific issues, in which case we'll have to respond to those on an individual basis. So the ones that I can answer fairly quickly, a few questions in relation to protected areas. We have a new ICT system, as I mentioned earlier, coming online called Acknowledge. Protected areas will be clearly identified on that, as will all our information. That will include all Aboriginal cultural heritage that the department is aware of. It's worth noting at this point in time that there is plenty of Aboriginal cultural heritage out there that the department isn't aware of, that hasn't been shared with the department. And there are a couple of reasons for that. Often, if it's particularly sensitive, Aboriginal people involved may not want to share that with the department or have it on a public-facing website for that reason. And also, we are certainly aware that individual proponents will have information about Aboriginal cultural heritage that has been identified via surveys, and that hasn't been shared with the department, usually at the request of the Aboriginal people themselves, because again, they don't want to share that information. They might be happy to share it with an individual proponent just to make sure that's taken into consideration when the proponent is undertaking the activities in question, but not wanting to make it more broadly available. In terms of those 78 sites, yes, they will be on our website, and so people will be able to identify, as I mentioned already, that we are engaging with people who may have an overlap with them. And if you feel like you should have been engaged, please email us separately, and we'll follow up. In terms of a question around appeals processes in the event of a dispute between a heritage application and owner. So the process involved will be where a proponent is seeking to undertake an activity. So they will need to have that lawful ability to undertake an activity in the first place. And that's where, depending on the level of activity, the type of activity that's being undertaken, will determine the type of approval, how high level an approval is required, and if that agreement can't be reached, particularly in relation to management plans, then it will eventually be escalated to the minister. In relation to LARCs, and just a couple of questions around LARCs and the council. There aren't any LARCs that have been established as yet. The ability to appoint the LARCs currently does exist, so the relevant sections of the Act and regulations have been put in place so that Aboriginal organisations can apply to become LARCs. I mentioned earlier that the government has established a readiness grants program, and that readiness grants program is providing funding, making funding available to assist Aboriginal organisations to determine, to have a look at their existing organisation and to look at the roles and functions that are set out under the Act as to what a LARC should be needing to undertake, the roles that we doing moving forward, and to actually do that internal assessment as to whether or not they're ready to take on that role of being a LARCs. And there's been a very strong interest, very pleased to say there's been very strong interest in that grants program. So it's clear that there are quite a number of Aboriginal organisations that are having that consideration to being a LARCs, but are in fact taking advantage of the opportunity to do that internal assessment before they do so. There's no requirement for that, for such a grant to be obtained. The Act does entirely make it a separate process, that if Aboriginal organisations want to be designated as the LARCs, they need to apply as per the process set out in the Acts and the regulations. And the council has also set out a designation framework to help guide potential applicants as to what the council will be expecting in terms of the information to be made available to it that will need to satisfy the criteria that are set out in the Act for any potential larks. In terms of the council, a couple of questions about how the council operates and how busy the council is going to be. Absolutely, the council is going to be very busy moving forward. We are putting in processes to ensure that the council is supported. There are also statutory timeframes that apply to the council, so the council will in fact need to be making decisions fairly promptly. They're not, as for the vast majority of boards and committees across government, they're not actually employees of the department. It's an independent body that provides advice to government, provides advice to the minister, and is supported and assisted by the department, but they're not employees of the department, and they're not employed on a full-time basis. But they're certainly very aware, and certainly when they put their hand up, that this is a highly significant role that they're choosing to undertake, and certainly the council to date has been extremely engaged in its functions so far. In terms of questions around knowledge holders, they are identified in the Act, and the new directory where we do have that information will identify who knowledge holders are, but there are also some knowledge holder guidelines that I'll be getting onto a bit later on to help with that identification process. There's some questions, very specific questions around specific activities, so I'll wait till I've dealt with the activity tiers, because I think in many instances they will be answered. And I'll be going through the process for when a management plan is required, and possibly some confusion in terms of my reference to Jiggin Gorge and the age of the rock shelters. I've mentioned that it's one of the it's one of the oldest sites that we're aware of. It's certainly not the oldest site, but its age was the age of it was certainly understood to be much more significant than it was when it was first considered as part of the Section 18 process in 2013, and that 46,000 years is certainly one of the oldest known sites that we currently have in Western Australia, but it's certainly not the oldest. And there's also a question around the EPA process and the overlap between the Aboriginal Cultural Heritage Act and the Environmental Protection Act. I was going to touch on that later, but I'm happy to touch on that now. There is that duplication between the two processes. So under the Environmental Protection Act, the definition of an environment under that Act includes social surroundings. That includes involves cultural surroundings, so it applies to cultural heritage. It applies to both Aboriginal cultural heritage and non-Aboriginal cultural heritage, and is a consideration that the EPA, the Environmental Protection Authority, needs to take into consideration. The EPA and the department that supports the EPA, the Department of Water and Environmental Regulation, very aware of the new Aboriginal Cultural Heritage Act and how it is much more thorough and detailed in terms of how it does deal with Aboriginal cultural heritage and the statutory processes that are in place. There have been many discussions between the two agencies as to how that overlap can be achieved. We're still very much working through that, but it is certainly a priority of government as well as the agencies themselves to try to resolve that as soon as possible, so that that duplication is minimised to the extent possible for proponents. Not wanting to come back. Okay. Just having yet another IT glitch. I want to get back to, sorry. Oh, I did, yeah, so anyway. Okay, so I will now finish going through the key parts of the Act. and then I will move on to some of the more detailed provisions, such as activity tiers and the due diligence process, which hopefully will answer a number of the questions that have come through. As I mentioned earlier, the Minister can now issue a range of orders as provided under the Act. These include the stop activity orders and prohibition orders. So these can be utilised by the Minister where there is in fact unauthorised harm or where new information has arisen. So where people haven't gone through the right process and haven't got the appropriate approval, there's now an ability for the Minister to intervene where there isn't under the current Act. And as I mentioned, that is very much modelled on the Heritage Act and the similar powers of the Heritage Minister to intervene where there might be authorised impact to heritage that may be of state significance. That's not Aboriginal cultural heritage that may be of state significance under that Act. And this applies also with this new information. So if new information does arise that people weren't aware of before, then the ability for the Minister to intervene applies there as well. Protection agreements, a new part that was inserted in response to quite a lot of submissions that were received on the draft bill that was released in September 2020. There was feedback that while the Act did include many improvements and did have particularly good provisions around things such as ancestral remains, secret and sacred objects and protected areas, that in terms of the approval process, that it was quite negatively focused, that it was all about potential harm to Aboriginal cultural heritage and how that harm would be managed, and that there are in fact proponents and Aboriginal people who do just agree on the identification, recognition and conservation of heritage. That there's not an intent to cause harm. It's a positive obligation that is being agreed to. It's a recognition that there is heritage out there and that both parties are keen to have that recognition and put in place steps to conserve it without any intent to cause harm to it. And that if that were the case, then it would be good if that could be recognised through the new Act and the new processes. So hence Part 8 with the ACH protection agreements was created that allows for those for that recognition and conservation and positive management steps. These agreements can be submitted to the council for its endorsement. It's not a requirement for that to occur because then they're not causing harm. But if the parties want to submit them to the council so that the council can formally endorse them, then that process exists and that can certainly occur. The new directory is being set up as part of the new ICT system. So our new ICT system is called Acknowledge, ACH Knowledge. It will replace the current register and will essentially capture all the information that we have under the new system. So it will include all Aboriginal cultural heritage for which the department is aware. It will clearly identify protected areas. It will identify where permits and management plans have been approved or authorised. It will identify where LARCs have been appointed, and any information that we have on knowledge holders will also be included there, although it's worth noting that knowledge holders are private individuals, so we'll only be including information that people are happy to share, particularly in relation to contact information. So no private contact information will be available without people's consent. We will also be endeavouring to have an overlay with native title in terms of prescribed bodies corporate, so people can identify if there isn't a LARC to the prescribed body corporate or who the regional corporation is that they will need to contact. As mentioned on a slide right at the start, both the current Act and the new Act do have that duty to report Aboriginal cultural heritage. There's an exemption for Aboriginal people for obvious reasons. If it's their heritage, there shouldn't be any legal obligation to report it to government. It's a voluntary thing. However, that obligation does exist for everyone else. Again, in response to submissions that were received on the draft bill, that exemption has now been extended to people who are requested by those Aboriginal people. So we were keen to avoid a tension between the Act saying that you had to report it and the people whose heritage is saying we don't want you to report it to government for whatever reason that might be. So if that request does exist, then the exemption extends there, but otherwise there is a positive obligation to report Aboriginal cultural heritage. The directory really is intended to be as much as possible a a very important data set, a very useful data set for people to have access to undertake initial questions as to whether or not there's anything present. Offences and compliance. So, as I mentioned earlier, the penalties have been substantially increased. The maximum penalty under the Aboriginal Heritage Act is $100,000. Under the new Act is $10 million. And it's probably worth noting, and apologies for those that may have heard me give this example before, but it is worth noting that when we were undertaking consultation on the new bill, that there were particular groups and individuals who did raise an eyebrow at the $10 million and suggest that in some instances that might be a blip on the balance sheet, and that perhaps an additional 0 or 2 should be added to that maximum penalty. Government didn't decide to do so. It did decide that $10 million was a sufficient maximum penalty, bearing in mind that the penalty applies to proponents of all sizes, and so it had to recognise that. As far as we're aware, that is the highest penalty for any harm to Aboriginal cultural heritage in the country, and there are also imprisonment penalties that apply, which will also should also act as a disincentive for people doing the wrong thing. In some respects, even more significant, though, is the increase of the statute of limitations period within which prosecutions can be brought. So under the current system, there's a 12-month limitation from when the offence occurs. So it is from when it occurs rather than when we might be informed of it, to a prosecution being brought. And as you might expect in a state the size of Western Australia, the vastness of the areas where Aboriginal cultural heritage is located, and the difficulty of necessarily going out on country and identifying whether there might be an offence that's occurred, and for an investigation to occur, 12 months has proven problematic in bringing investigations being carried out. This is evidence to some degree that we've had a dozen or so successful prosecutions in the 50+ years of the Aboriginal Heritage Act, and a significant reason has just been that limitation on being able to do the appropriate investigation and bring a prosecution case, which involves seeking legal advice as well within that 12-month period. So that 6 years does reflect other statute of limitations in other legislation, and does ensure that there's proper opportunity for any breaches of the Act to be appropriately investigated. Consistent with that, the Act does appoint inspectors. So we currently do have an investigations team within the department who carry out investigations, and so they will be the formal inspectors under the new Act. In recognition of the role of Aboriginal people in relation to their heritage, and the fact that, as I'm sure you would expect, the vast majority of instances where we're advised that there may have been unauthorised harm are obviously by people reporting to us, and in particular Aboriginal people reporting to us. Recognition that Aboriginal people obviously know country best and will be out there, and also in the form of things like the ranger programs that exist. And so in recognition of that, the Act does allow for Aboriginal inspectors to be appointed. They won't have the full range of powers of the government inspectors for obvious reasons. Government inspectors are bound by things such as the Public Sector Management Act, and Public Sector Code of Ethics and other requirements within the department. But it does have that recognition that Aboriginal people are often well placed to be out on country and to identify whether things have been done in an unauthorised manner, and this is about trying to give that recognition to that and to facilitate that as part of the process. Also really significantly is that there is available compensation to Aboriginal people. So again, this was in response to very strong representation, that if someone has caused unauthorised harm and that it does go through the prosecution process and that they are then penalised by the court, that the penalty shouldn't then go back to the state. It's not the heritage of the state that's been harmed, it's the heritage of the individual Aboriginal people or their community that has been harmed, and there needs to be the recognition as such. And so any penalties that are imposed will go into a separate account within government, and will be then be able to be available as compensation to Aboriginal people where that harm has occurred. one of the new powers of the minister is to issue remediation orders. To issue a remediation order against a proponent that has done the wrong thing. But we're also aware that Aboriginal people have certainly said that if someone has done the wrong thing, then a bit like putting the fox in charge of the chicken coop, why would you ask the person who's done the wrong thing to then be the person to put things back? And in fact, it's the Aboriginal people whose heritages who would much prefer to be in control of that process, and that if in fact there has been a penalty that's been imposed, then that penalty should be available to assist in that remediation. So we certainly think that that will be the kind of example where compensation can be provided. It's not limited to remediation, but that is certainly one aspect of it. This is the 5 members of the current council. So in the middle is Minister Butty, Minister for Aboriginal Affairs. On either side of the minister are Irene Stainton, who's a senior Noongar elder, and on the other side of the minister is Mark Bimbaka, who's a senior Aboriginal person from the Kimberley. Standing behind Mark is Mel Carter. Mel is also a senior elder from the Kimberley region. Behind the minister is Graham Castledine. Graham is a highly experienced lawyer who has worked in the area of native title agreements for many years now and has lots of experience in negotiating agreements between Aboriginal parties and proponents. And behind Irene is Dr. Debbie, is a former senior person within the Department of Premier and Cabinet and played a senior role in terms of negotiating Indigenous land use agreements as part of the Southwest Settlement and Yamatji Nation processes. Debbie has since left government and is a private consultant and has a plethora of experience in this area to assist on the council. 2 people missing from the photo are Kevin Wally, who's a senior elder from Meekatharra Way, and Belinda Morich, who is also a lawyer and has got a very strong environmental and planning background. As I mentioned earlier, we've got the government had an EOI process that's gone out and closed on the 30th of April to fill the 4 remaining positions, and the minister will be announcing those positions prior to the new act coming into effect on the 1st of July. Just very quickly, this slide shows our co-design process and schedule last year. So we undertaking co-design process on 10 key documents that I'll be going into more detail shortly. But it shows that we did do everything possible to go all around the state to engage with people. Phase 1 was only 12 locations, and that was principally because of the implications of COVID, limitations being imposed by COVID. But subsequent to that, we could significantly expand the number of locations that we went to. And as you'll be able to tell, we obviously did target Aboriginal communities just to make sure that we were reaching out to people who had a particular interest in this. And as you will see from the number of submissions received, over 220. So, challenges of the co-design process that we undertook last year. We did have less than 12 months to co-design important documents. We had about 9 months or so to actually undertake the 3 phases of workshops. This was very much because the government was very keen to get the new legislation into effect as soon as possible. And again, this is a response to feedback by Aboriginal people, but also by proponents, that the current system is manifestly inadequate and that we needed to move to a new system, particularly around allowing for the negotiation of management plans sooner rather than later. So hence the very tight time frame for the co-design process. Clearly a large range of stakeholders with a disparate range of views involved. So in many instances, very difficult to reach at agreed positions between those different stakeholder groups, and that's certainly identified through the process of actually finalising the documents themselves.